and that video recording is part of the public record and will be available online. So in light of that, please be aware that any information shared during this hearing will be publicly viewable. Good afternoon. I am Administrative Law Judge John Johnson. I'll be the lead ALJ for this hearing in the matter of Medivation, Inc. I want to thank all the participants for joining us today. It looks like we have everyone we're expecting today. We'll give formal introductions when we get on the record. Before we do that, we will go over a couple announcements off the record, kind of recap where we are after the pre-hearing conference and make sure we're all ready to go for the actual hearing. Okay. During this period off the record, please feel free to interrupt me if you have any questions or comments or anything seems unclear. Present is our hearing reporter, Ms. Alonzo, who is reporting this hearing verbatim. To ensure we have an accurate record, we ask that everyone speaks one at a time and does not speak over each other. Also speak clearly and loudly. When needed, Ms. Alonzo or a panel member will interject to ensure proper transcription. After the hearing, Ms. Alonzo will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. To help ensure we create a clean record today, I'd ask that you please mute your microphone whenever you're not speaking. And also, importantly, wait to respond to prompts or questions until the previous speaker has completely stopped talking. Once we go on the record, I will restate the issue on appeal and enter the exhibits into the record. On the issue, after the pre-hearing conference, the appellant submitted suggested revised issue statement incorporating section 23036. I appreciate the minimalist approach to the revisions. To make it sound a little smoother, I suggested an alternative of whether revenue and taxation section 23036 D1 allows appellant to reduce its alternative minimum tax liability using the research credit provided in Revenue and Taxation Code section 23609. I think it's largely the same, just kind of reworded a little bit. Appellant, does that issue statement sound okay to you? Okay, and Franchise Tax Board, does that sound good to you?
I'm trying to push my mic. Sorry.
It's a bit of a push.
No objections at this time. Is that how the issue will be presented in the opinion?
That's the idea.
Oh, okay. Then we do have an objection because we don't think that 23036 is the only statute at play today. It's also We also are concerned about 23609, the research credit statute. So I don't think that's the entirety of the issue. But
okay. 23609 is referenced at the end of the issue statement. Does that alleviate some of it? Or do you want me to include both 23036? Sorry.
I would prefer both.
Both of them up top?
Mm-hmm.
Okay. I'll try to find a happy medium between all of that.
I'm sure you'll figure it out.
Thank you. Okay, on to exhibits. Respondent submitted with its briefs exhibits A through C, subsequently provided exhibits D and E. Appellant submitted with its briefs exhibits relabeled as 1 through 15. A hearing binder with all exhibits was distributed to the parties. I want to make sure both parties got those exhibits.
Yes, we did. Thank you.
Yes.
Thank you. Is the microphone working for you? Do you want us to try to switch it?
It's fine. The button just seems to be a bit
tough
to compress. But
all right.
Yeah, I'll figure it out.
Did either party appellants, do you have any objections to those exhibits?
No, we don't.
Okay, and Franchise Tax Board?
No objections.
Okay, and does either party have any additional exhibits to provide today?
We do not.
No.
Thank you. Once we go on the record, I will enter those exhibits into the record as evidence. And then after that point, we'll be ready for the parties' presentations. As a reminder, appellants will start first. You'll have 1 hour for your presentation. After that, we'll have any potential questions from the panel members. At that point, we'll likely take a break for about 10 minutes. When we come back, respondent, you'll have 1 hour for your presentation, followed by any questions from the panel, and up to 30 minutes for rebuttal from appellants, and finally, any panel questions, of course. If you have any questions once we go on the record as we're proceeding, or if you need to take a break, please let me know. I only ask that you refrain from interrupting the other party during their portion of the presentations unless absolutely necessary. I'll likewise keep any interruptions from me to a minimum. But let me ask now, before we go on the record, are there any final questions or comments from appellant?
No.
Okay, thank you. And from respondent?
No.
Thank you. We are now on the record. This is the appeal of Medivation, Inc., OTA case number 2204-10165. It is 1:05 p.m. on October 21st, 2025, here in Sacramento, California. This hearing is being led by myself, Administrative Law Judge John Johnson. My co-panelists today are Administrative Law Judges Kenny Gast and Josh Lambert. They are co-equal decision makers in this appeal. I'd like to remind today's participants and viewers that the Office of Tax Appeals is not a court, but is an independent appeals body. The office is staffed by tax experts and is independent of the state's tax agencies. The decision on appeal will be based solely on the arguments and evidence provided by the parties on appeal in conjunction with an appropriate application of the law. The panel has read the briefs and examined the submitted exhibits, and we are looking forward to your presentations today. Let's have the parties introduce themselves, starting with appellants.
Thank you. I'm Annie Huang with Pillsbury Winthrop Shop Pittman for the appellant, and sitting next to me is Frances Sewell. She is the state tax director for appellant.
Okay, thank you. And are we close enough to the mic on that one?
If you could bring it closer to you, that would be great.
Okay, is this better?
A little closer?
Okay.
Or louder?
How about that? Still not?
There you go.
Okay.
Thank you. And introductions from Respondent Franchise Tax Board.
Good afternoon, Matthew Miller for the Franchise Tax Board.
Casey Llewellyn for the Franchise Tax Board.
Thank you. The issue on appeal is whether Revenue Taxation Code Section 23036D1 allows appellant to reduce its alternative minimum tax liability using the research credit provided in Revenue Taxation Code Section 23609. Appellant has provided Exhibits 1 through 15. Respondent has provided Exhibits A through E. No objections to those exhibits. They are hereby admitted as evidence to the record. At this stage, unless there are any questions, we are ready to move forward to the parties' presentations. Ms. Wan, if you are ready, you have 1 hour to present.
Thank you. Good afternoon, and thank you for your time today. So as Judge Johnson just mentioned, that the issue here is whether appellant can use its research credits to reduce its alternative minimum tax liability. And the answer is yes. A review of Section 23036D1, the legislative history, FTB's own analysis of the AMT back in 1992, and also the appeal of NASCO would dictate that result. So as a preliminary matter, I'd like to address the appeal of NASCO since FTB has requested that this panel overturn that decision. First of all, NASCO was decided 15 years ago. And in the ensuing years, the legislature has not done anything to change the law, despite FTB's very public dissatisfaction with that decision. So then FTB and NASCO as well petitioned the State Board of Equalization to review that case. And the SBE, in its order, a published opinion, stated that it was not contrary to law, that it review all the alleged history. It, of course, it first considered the statutory language and found that there was ambiguity, reviewed the legislative history, and found in favor of the taxpayer. What we have here is exactly the same thing. So, but going back again to the FTB, FTB's position is that the decision was flawed. In fact, the FTB has called this decision nonsensical. And I find that position very astounding. The SBE, before the OTA was established, was tasked with reviewing cases from the FTB for decades. And the FTB is saying it doesn't matter. Only their interpretation is correct. And again, this is not the only case that FTB has involving this issue. You have decades and decades of experience from tax practitioners in California state tax law, also disagreeing with FTB on its interpretation of 23036. However, the FTB still insists that its interpretation is the only correct one. So FTB is unhappy with NASCO, but that is no reason to overturn a 15-year-old precedential decision. Courts have, of course, overturned prior decisions, but they do it very, very rarely. The party seeking to overturn a decision, in this case the FTB, has substantial burden to prove that the decision was wrong. And like I just said, the FTB tried that once already in its petition for rehearing 15 years ago and was soundly rejected. And now the FTB is trying again for a third bite of the apple at this exact same issue, exact same arguments. The arguments were no different than before. And so the FTB's position is simply overturn NASCO. Let's start over again, is essentially what they're arguing. For purposes of FTB's position, where they say ambiguity is not there, we disagree. And I would like to turn to, this is the one area where the FTB, despite the fact that we have provided the information in our briefs, the FTB has never addressed it. So back in 1987, when the AMT was enacted by the California legislature, part of the requirement was for the FTB to prepare a study on the AMT and to present it to the legislature. So in 1992, the FTB did so. After 5 years of studying the AMT, they did a report, a study that talks about the AMT and the various things that that is involved in the AMT calculations, the history of it, the policy behind it, and how it's calculated. And if you look at Appellant's Exhibit number 6, if I can turn the panel to that exhibit, looking at page 7, the FTB here talks about the steps of how to calculate the AMT. And if I may read from it, just so it is clear what the FTB is arguing here versus what it said back then, is that finally, this is step 4 in the middle of the page, finally the effect on tax credits must be calculated. With several exceptions, taxpayers with an AMT liability may not claim any tax credits. Thus, for these taxpayers, their total AMT effect is the sum of their direct AMT liability and their loss of tax credits. Then it references us to footnote number 3. Footnote number 3 says the credits for which this restriction does not apply in California includes solar energy credits, the renter's credit, the research expense credits, the credit for clinical testing expenses, and so on and so forth. And if we turn to exhibit number 7, this is a list of all the credits in existence in 1992. And as you can see, in FTB's footnote 3 in exhibit 6, those are the credits that are shown in exhibit 7, which are the credits under 23036 D1 back in 1992. So when you look at what the FTB did back in 1992, it clearly agrees with the NASCO decision. However, the FTB, in one of its briefs, claims that this is a preliminary report and therefore dismissed it out of hand. They have absolutely shown nothing to say this was changed. They have never tried to explain why their position more than 30 years ago is different from their position now. And on top of that, going back to NASCO, is that how can the SB decision in NASCO be flawed or nonsensical when it simply agrees with what they said back in 1992? So for all the reasons I just stated, the NASCO decision should stand. The FTB agreed with it in 1992, like I said. The legislature has amended 23036 D1 several times since NASCO and has never changed the law. And SBE itself is a separate state tax agency, and it disagrees with the FTB. So at the very least, you have ambiguity there, right? Even if you don't agree with the SBE's interpretation, you gotta agree that there's ambiguity. It cannot be that the FTB's interpretation is the only one that is permitted under the law. Because in order to get ambiguity, you just need to have more than one reasonable interpretation. I would say that's met here. Certainly, there's a reasonable interpretation by the SBE, by the various tax practitioners with decades of experience. How is it the FTB is the only one that is correct? Therefore, so moving on, with NASCO being a presidential decision and determining that there is ambiguity and that the credits under 23036D1 should be allowed to reduce the AMT liability. Understand that NASCO was specifically focused on the MIC and the easy hiring credits, but the reasoning in NASCO equally applies here. But just looking at what we have here in terms of ambiguity, I would like to address that as well, even though we believe NASCO already addressed it and it's still good law, is if you look at 23036D1, right? The FTB argues that there's only one way to read 23036D1, which means tax, in quotes, does not include AMT. The FTB likes to reference subdivision A, and subdivision A talks about, as we read it, the term tax includes any of the following. It doesn't say only includes, it doesn't say means, it doesn't say defined as, includes. Include means it can include all sorts of things other than what's listed. That's the definition of includes. It's not limiting, it's not exhaustive, it means includes. So you have under B, it then talks about the AMT. And then you have D, subdivision D, that just says tax in quotes without any definition. The FTB likes to define that as regular tax. However, regular tax is defined in 23455C. I don't see that in 23036, D, A, or A, right? So what you have here is you have D that says a credit may not reduce tax below tentative minimum tax as defined by paragraph 1 of subdivision A of section 23455. So the legislature clearly knows how to reference another code section, which it did here in defining tentative minimum tax, but it doesn't do that to define the word tax. So what despite FTB's efforts to simply limit the word tax to regular tax, nothing in the statute allows that. It doesn't exclude AMT. It doesn't have anything that would say AMT should not be included in that word.
And can I ask you, please, just once again, come a little bit closer to the microphone?
Oh, sorry.
Okay. But I think you're pretty good right there.
Okay.
Thank you.
So what we have now is the word tax is ambiguous, as the SBE determined in NASCO. It is curious and telling that the FTB has fought every step of the way to review the legislative history because they keep insisting that it is not ambiguous. However, the law does not prevent looking at the leg history when the leg history helps look at the legislative intent. As Lundgren versus Tugmajan said, plain meaning rule does not prohibit a court from determining the literal meaning of a statute comports with its purpose. The intent prevails over the letter, and the letter will, if possible, be so read as to conform to the spirit of the act. And in doing so, we should look at the legislative intent. What is the spirit of the act? Generally speaking, as the issue here is, all these credits, and it's throughout the leg history, these credits are meant to help taxpayer, to encourage certain behavior from taxpayers. They are of overriding importance to the legislature when they enacted these credits. And for that reason, they wanted to make sure taxpayers could get full benefit of these credits. And if you look at the ledge history, they all say that. You know, they say that it's very clear that these credits are meant to reduce the AMT. And if I may take the panel through some of these exhibits, if I could start with Exhibit 2 of appellant's exhibits. If we look at page 1, under, it says number 5 here, various policy cleanup. By the way, this is, I should also say, this is in 1989. AB 802 is a statute that added the research credit to 230361. So what you have here, so this, what, over here, and Clays, Mr. Clays was the author of the bill. So we, in Exhibit 2, on page 1, it says various policy cleanup. Bullet point number 1, R&D/orphan drug credit against AMT. In the same document, if you, Exhibit 2, page 2, it says current state law allows a credit for certain research and development expenses similar to that allowed in federal law. Current law also allows a credit for research and orphan drugs. Neither credit may be used to reduce alternative minimum tax. The AMT may only be reduced by the solar and the low-income housing credits. That's how I explain current law. But with this new bill, the proposal was to allow the R&D and the orphan drug credits to be taken against the AMT. And then it talks about the sunset date of the credits. And if I could turn you to Exhibit 3, page 1, this is Mr. Clays writing to the governor, urging him to sign the bill, is the last paragraph on the page, page 1. It was necessary to place 2 nonconformity items in this bill in order to make this revenue neutral. The first provision allows the research and development credit to be fully claimed by companies which are subject to the alternative minimum tax. The second removes some significant administrative obstacles from the employer child care credit, which you signed into law last year. These corrections are crucial for making these credits work properly. And then if we turn to Exhibit 4 on page 1, this relates to AB 57. However, I know this is the order the exhibits, but because of the briefs, there are other exhibits. If I could jump ahead to exhibit number 9 that also talks about 802, AB 802, the research, the one that put in the research credit. So it says here, this is page 2, towards the bottom, non-federal conformity items with significant fiscal impact. Tax credits allow to reduce the tentative minimum tax. Allow the credits for research expenditures and clinical testing of orphan drugs reduced the regular tax below tentative minimum tax. And then you have number 10, Exhibit 10. This then goes, now we're going back to 57, AB 57. And if I could explain why we're also talking about AB 57. AB 57 was the bill that was discussed in NASCO. So the State Board of Equalization did look at the legislative history for AB 57 quite in detail. And we are including this here because it does reference the research credit, since AB 57 was put in after AB 802. So if I could, we can continue on with Exhibit 10. On page 1, it says here, the alternative minimum tax is imposed to ensure that taxpayers who receive a large amount of tax benefit pay some minimum tax. Generally, tax credits cannot be used if the resulting net tax liability is below the AMT. There are some credits, however, such as the low-income housing credit, the renter's credit, and the R&D credits, which may be used even if their use would have been such a result. Not permitting the application of tax credits under such circumstances limits the impact of the credit. And then further down the second paragraph, because as a reminder, this is talking about the AB 57 is about the easy credits. So currently, if the business is subject to the AMT, the business can get no benefit from the credit. This bill would permit the business to apply the credits and reduce their liability below their AMT, permitting some additional use of the credit. Going on to Exhibit 11 on page 1. Existing law also generally conforms with the federal alternative minimum tax, which in effect prevents taxpayers from using various credits, deductions, exemptions, and other special tax benefits to reduce their tax to zero. Tax credits are generally not permitted to be taken in computing the AMT. However, there are certain exceptions which may be used in computing the AMT: low-income housing credit, renter's credit, solar credit, research and development credits, orphan drug credit. In the next page, we can see that the third paragraph, right above the fiscal effects section, it says, this bill is intended to make the full benefits promised under the Enterprise Zone Program area and the Los Angeles Revitalization Zone concepts available whether the taxpayer is subject to regular tax or alternative minimum tax. So it is very clear here that despite what the FTB is arguing, the AMT is allowed here, where the FTB is saying no, that the taxpayer cannot use their research credit to reduce their AMT. We can see in all the documents here that I just read that it states that taxpayer can use their tax credit to reduce their AMT. But if I could turn the panel back to Exhibit 4. Where on page 1, just like what I read the last few documents, it does talk about that credits are generally not permitted to be taken in computing the AMT. However, there are certain exceptions which may be used in computing the AMT. Okay, sorry. So it includes the low-income housing credit, renter's credit, solar credit, research development credit, and orphan drug credit. But the next page tells you why the legislature decides that these credits can be used to reduce the AMT. On page 2 of Exhibit 4, the alternative minimum tax was enacted at the federal level and conformed to by California, with the objective of preventing a taxpayer, whether individual, partnership, or corporation, to use various combinations of tax benefits to reduce tax to zero. However, some of those tax benefits have been determined by the legislature to be of such overriding importance that exceptions were made to computing AMT to, in effect, authorize use of the credit against either the regular tax or the AMT. Overriding importance is why these credits were allowed to do so. If we look at what the legislative history shows, it is undisputed that the research credit was meant, the legislature, I should say, meant for taxpayers to use a research credit to reduce its AMT liability, because that's the only way that the full benefit of the credit could be achieved. Now, the FTB, like I stated earlier, throughout the briefs have resisted talking about legislative history, just like they did in NASCO. But 14 days ago, they did provide, as you noted, Judge Johnson, earlier, they did provide Exhibits D and E. And Exhibit D is 137 pages. So if I could turn to some of the things that the FTB provided as part of their Exhibit D, instead of supporting their position, Exhibit D supports taxpayers' position. Some of these documents are also, the same documents that I just read as part of appellant's exhibits. But if I may, go to some of the exhibits that the FTB provided and highlighted we can see that they do not support FTB's position, but in fact supports appellant's position. So if I could ask the panel to turn to Exhibit D, page 5 of Exhibit D, where it's highlighted by the FTB in that block. Middle of the block says, in other words, even if the taxpayer is subject to the alternative minimum tax, the R&D credit and the orphan drug credits would partially apply. This is in contrast to the federal practice under which these credits are inapplicable if the taxpayer is subject to alternative minimum tax. Then if I can turn to page 20 of Exhibit D. Again, it basically repeats what I've been reading the last 10 minutes, 15 minutes. It states that AB 802 adds the research and development credit and the orphan drug credit to the list of those which are allowed to reduce the regular tax below the 10 minimum tax. In other words, even if taxpayer is subject to the alternative minimum tax, the R&D credit and the orphan drug credits would partially apply. This is in contrast to the federal practice under which these credits are inapplicable if the taxpayer is subject to alternative minimum tax. The same language could be found on page 28 of Exhibit D. Because it is essentially the same language, I won't read it, but if I just would like to point it out to the panel. Then if I could turn to Exhibit D, page 37, under also the highlighted portion. 6 says, allows research credit and orphan drug credits to offset the alternative minimum tax. And what's interesting in this document is that this particular document is about AB 802, and it's a bill analysis. It's for concurrence in Senate amendments. So with this, if you look at page 40 of Exhibit D, this attachment, is the estimates for various provisions in the bill. And under here, you can see, under other provisions toward the bottom, it says tax credits, AMT. So it is included in the revenue estimates as something that the tax credits as being available to be used against AMT. Now, if we turn to Exhibit D, page 41, this is about the Los Angeles Revitalization Zone, the LARS. And for this, on page 41, it does also say, this bill permits business operating enterprise zones and the Los Angeles Revitalization Zone to reduce their tax liability below their tentative alternative minimum tax by applying credits authorized to businesses operating in the zones. If you go to the next page, it says the tax credits are generally not permitted to be taken in computing the AMT. However, there are certain exceptions which may be used in computing the AMT, and one of them is the research and development credits. And further down, again, the same page, right underneath the blocked, highlighted section by the FTB, it says this bill is intended to make the full benefits promised under the Enterprise Zone program area, and Los Angeles Revitalization Zone concepts available whether the taxpayer is subject to regular tax or alternative minimum tax. So there are several other ones, instead of taking the entire hour to read the rest of these, which I'm sure the panel has already seen them, I would just like to take a little more time to read some of them. So part of this is the FTB has also included several documents in here that talks about the credit ordering rules, which we believe are irrelevant to this discussion. I want to point out that these are on pages 93, believe. Oh, pardon me, from 77 to 92. They have to do with the credit ordering rules, which are relevant to the issue of whether taxpayers can use their research credit against AMT under 230361. If I could turn to page 55 of Exhibit D, I want to point out again where the legislature has talked about the regular tax as well as the AMT. So Exhibit D, page 55, this is for the MIG. It says here, the second paragraph in that box, that red box, the credit may be used to reduce regular tax liability or alternative minimum tax liability. So all these leg history either talks about only about the AMT or it talks about regular tax or the AMT. So Exhibit D, page 61, talks about LARs, again, could be used against the AMT. That's the language here. And I would also like to point out something when, in terms of whether the bill really meant what it said. You know, in the legislative history, this one is about, this one is for the MIG, I believe. Oh, no, this is for the LARs. So what we have on page 63 of D, all the highlighted boxes talks about allowing the ZARs to be claimed against the AMT. But what is interesting here to me is at the very bottom, it talks about arguments in opposition. It says here, California Tax Reform Association states the alternative minimum tax exists to limit the ability of highly profitable companies to utilize so many credits and exemptions that they pay no tax. CTRA does not believe the enterprise zone benefits should be so extensive that profitable companies are essentially tax-free. So even the people in opposition understand, right? This was what, in the early 90s, that they understood back then that this is what the bill did, that you could use the credits to offset your AMT, where you essentially pay zero tax. This is contrary to what the FTB's position is, which is that if, as the NASCO decision stated as an example, is that FTB's position is that if you have a taxpayer where the regular tax is about their TMT, which are two separate and parallel calculations, then taxpayer one with that situation could use the tax credits under D1, subdivision D1, to reduce it to zero. But if it flipped, where the TMT is higher than the regular tax, then you cannot do so. But with all that we just read here, even in the leg history provided by the FTB, there is an overriding importance to these credits. That legislature wanted to make sure that taxpayers can get the full benefits of these credits, that these credits needed to be allowed to be used to reduce the AMT for them to work properly, as Mr. Clay said to Governor Deukmejian back in 1989. And then so the FTB then continues on. He talks about the film credit, and then also the Go Biz credit. And in here, the Go Biz, this one is Exhibit D, page 125. Pardon me, I gotta hold this a little bit further away from me. So it says here, the authors have proposed several amendments to the bill. This is for the film credit, by the way. One, among others, one, conform to existing law by allowing the credit to be used to reduce a recipient's tax below the alternative minimum tax, and therefore fully monetize the credit. And then the next one that the FTB has, or the last one in terms of the credits here, is the Go Biz credit. So this is Exhibit D, page 126. In, again, the highlighted section, it says here, the second paragraph, usually state law does not allow taxpayers to use tax credits to reduce its tax liability under the tentative minimum tax. A part
Maybe you
of
could
the,
slow down a little bit more while you're reading, please.
oh, sorry. State tax law does not allow taxpayers to use tax credits to reduce its tax liability under the tentative minimum tax. A part of the alternative minimum tax intended to ensure that corporations that receive significant tax liability pay some share of the cost of public services. Without an AMT, corporations with significant tax credits can avoid taxes altogether when the value of the credits it applies exceeds its net income in a taxable year. And further down, it says here, generally taxpayers cannot use tax credits to reduce TMT. However, the legislature has allowed some credits to do so, such as research and development tax credits. While he talks about TMT, and that is the other issue, if I could use this time, and I apologize for jumping around here. The TMT and the AMT, in one of the responses to the OTA Foundation's division's questions about how the TMT and AMT works. And as NASCO has explained, as FTB itself has explained in its 1992 study on the AMT, as FTB has explained this case, as we have explained, so I think it's generally understood that you have two separate calculations, one for the regular tax and one for the TMT. And if it's above the rate, if the TMT amount is above the regular tax amount, that difference is the AMT. So the TMT includes the AMT amount. So it is impossible to separate those two. So the FTB, like I said, submitted 137 pages of exhibits where they, instead of supporting FTB's position, actually supports appellant's position. But in addition to that, as FTB has conceded in its last brief in response to OTS questions, there are several other amendments where the legislature added other credits to 23036D1. And if I may, turn you to those exhibits. We can go through those as well. So Go Biz was, like I said, Exhibit D stops with Go Biz in terms of legislative history. However, after Go Biz, we have the College Access Tax Credit, the Advanced Strategic Aircraft Credit, and another couple California Motion Pictures and Television Production Credits. The FTB does not talk about them, and appellant provided leg history for those credits as well. So if we can turn to appellant's exhibits 13 through 15. I will start with 13. Pardon me while I turn to it. So page 4 of Exhibit 13. Amendments add a new college access tax credit for 1 year, tax year 2017 under the insurance gross premiums tax and corporation tax. It adds the college access tax credit to the list of tax credits that can reduce the tentative minimum tax under the alternative minimum tax calculations for personal income and corporation tax. And then if we turn to Exhibit 14, this is about the Advanced Strategic Aircraft Credit. It says here, under this page 4 of Exhibit 14. 7, it says, Advanced Strategic Aircraft Credit. Specifies that for taxable years begin on or after January 1, 2020, and before January 1, 2026, the Advanced Strategic Aircraft Credit could be used to reduce the alternative minimum tax. And lastly, we have Exhibit 15, page 4. This is where the Advanced Strategic Aircraft Credit was extended. Because it was extended, 230361 was also amended to extend the use of this credit against the AMT. And this was the floor report for the 2024 to 2025 budget. And this was prepared in June of 2024. So as recently as 16 months ago, the legislature said in this floor report, it says, the trailer bill language to extend the timeline for when the Advanced Strategic Aircraft Credit could be used to reduce alternative minimum tax before January 1, 2026 to before January 1, 2031. Like I said, the dates just coincides with the extended credit. So all these years, starting in 1989, when the research credit was put in, until June of 2024, with the last addition to Section 230361, the legislature has been very clear that these credits under D1 are allowed to be used to reduce a taxpayer's AMT liability. The FDB has provided no arguments and no leg history to counter that. All FDB has said throughout, has insisted, both in NASCO and here again, is that you don't need to look at a leg history. You don't need to look at it because it's the language, the statutory language is not ambiguous. This overwhelming list of leg history in support of the taxpayer's position, appellant's position, and against the FTB's position, the FTB would just like the panel to ignore. But to sum it up, it cannot be ignored because, FTB's initial position that it's not ambiguous is incorrect. NASCO, the decision in NASCO went through it in detail, but as we noted, 230336A does not exclude the AMT. 230361 does not define the word tax as regular tax. The legislature certainly knows how to reference another statute for a clear definition, as it did for the tentative minimum tax for 230361, but it did not do so for the term tax. So in summary, we would like to say that first, the NASCO decision should stand as it is good law. The legislature knew of the decision, certainly did not change it. And the FTB has provided no reason other than it disagrees with it to overturn a decision that's been around for 15 years. And not only that, the NASCO decision agrees with FTB's own position back in 1992. And the leg history supports taxpayers' position that it can use its research credit to reduce its AMT liability. So for this reason, for all the above reasons, we ask that this panel sustain and the taxpayer's position and reject the FTB's position on this issue. Thank you.
Thank you. Let me turn for panel questions, starting with Judge Gast.
Yeah, I have one question. If the panel finds that the term tax in D1, is that too loud?
Oh, yeah,
I thought you were, okay. If the panel finds the term tax in D1 is unambiguous, so contrary to NASCO, do you have a position as to why you should still win?
If I may, Judge Gass, if I could rephrase it to make sure I understand you, is that you're saying that if this panel decides that NASCO was wrongly decided, and that that there's only one way to read 23036, is whether the taxpayer should still win. I would say that the taxpayer would still win because it is just, I hate to put it this way, but it's hard to imagine why it would only be interpreted one way, because the statute is not clear. You know, it talks about, if I may, sorry, if I may just reference the statute itself. I know the FTB, that is the FTB's position, and it has been, for the last 15 years since NASCO. And I do understand your question, Judge Gast, and I'm not trying to ignore it. But I just want to explain that it is that you have A1 that says the term tax includes any of the following, right? Includes. It doesn't say only includes. It doesn't say means or defined. It doesn't have that limiting language. If I say, this table, on this table, I have things that includes my glasses, my water bottle. That doesn't mean those are the only two things here. It's the definition of the word includes. And then you have B, right? It also says includes also. And then AMT is referenced there. Then you have D1, where the term tax is not defined. But like I said earlier, the tentative minimum tax is defined by a reference to a separate statute. So the legislature knew what it was doing. And I like to say also, if I may turn you to section 23036, sorry. So you have I2, where here the statute talks about regular tax. But in doing so, it says regular tax as defined in section 23455. Regular tax as defined in section 23455. You don't have that in D1. It doesn't reference 23455. It doesn't say regular tax. It has none of that. So FDB trying to insert a word in there, a term in there that is not contemplated by the statute. And again, referencing the alleged history, it supports that position. Supports a position that it is meant because of the overriding importance of these credits that are meant to encourage economic activity in the state. These credits, like economic activities that the legislature felt was very important, like vital to the economy of the state, that they want to make sure that taxpayers could take full benefits, that full monetization of these credits. And the only way to accomplish that is through the ability to use the tax credits against AMT. Otherwise, just as the example given earlier, if your regular tax is above your TNT, you're good to go. You can use the credits to reduce it all the way down to zero. But if you just happens to have where your TMT is higher than your regular tax, then you're out of luck. How is it possible that the legislature would treat two taxpayers so differently when the underlying tax is meant to encourage the same activity in this state? What the underlying tax has the overriding importance to the state. It makes no sense that that would be what is meant by the legislature.
Thank you. Just a quick follow-up there. So when I look at D1, it says a credit may not reduce the tax below the TMT. In the situation where you're saying the R&D credit can reduce the AMT, the AMT would have to equal the TMT. That's the only situation that this statute would make sense, I guess, D1.
Well, you would have the TMT, in situations here, like for appellant, right? They used their research credit to reduce their AMT. And so they used it all to bring it down to 0. So to answer your question, if that's the only situation, I guess another situation, if you look at it, right, is when you have the TMT over regular tax, and the TMT, let's say, is 500,000, and the regular tax is 300,000, right? So the AMT is 200,000. And so if in that case you should be able to use the credits to bring it all the way down.
Okay, yeah, I was just, it seems like the only situation would be the AMT equals the full value of the TMT, otherwise it wouldn't be below, it would be less than the TMT, because that would equal AMT plus regular tax, but,
If I may, I'm sorry to interrupt. I think maybe another way to look at it, so it is when you have the regular tax above the TMT, right? So in that situation, FTB agrees you can use the credit to bring it all down to 0. So the regular tax is above the TMT, and you can bring it all the way down to 0. So I guess your question is the other way around, where the TMT is higher than the AMT. So the tax, which includes AMT, you can bring it down, right? But then once you get to it would still apply, because if it's below the regular tax, right, it would include, you could bring it all the way down. Because again, I would compare two taxpayers. You have two equal taxpayers with the same economic activities that basically allows you to claim this credit, right? So you have one where you can bring it all the way down to 0. And then the second taxpayer would somehow be limited unless it's a specified situation that just happens to work a certain way. That would seem to that would seem to support disparate treatment for the same kind of credit. And so in terms of how the credits will work, the regular tax above the TMT would bring it down to 0. But the TMT above the AMT, in that case, they would
the
still bring it down
TMT
to
above
0.
the regular tax.
Right, or
Yeah.
get up the regular tax and you have the AMT, then you can bring it down below. And your question is, because of the language about the below the TMT, is that, then it wouldn't go below the regular tax. Is that the question you're asking?
Yeah, it was just, why does tax in D1 mean AMT when the only situation you can reduce tax below TMT is if the AMT equals the full value of the TMT? But
then I would say, then once you get under the TMT, when you get to regular tax, then as some of the language I have read, it says it could be used against the regular tax or the TMT, the AMT. So for that, you should be, and there should be no difference. I don't know if that answers your question.
that's okay, we can come back to it later.
Okay.
Thank you.
Thank you. And Judge Lambert?
I don't have any questions. Thanks.
Thank you. At this time, we will take a 10-minute break unless anyone needs longer, and we'll come back here at 2 o'clock. We are off the record. Please make sure your microphones are off. If we're ready, we'll go back on the record. Oh, if we're ready, we can go back on the record. Thank you. Okay, now respondent will have 1 hour for their presentation if they're ready, and just please try to stay close to the microphone.
Thank you. Good afternoon, Judge Johnson, Judge Gast, Judge Lambert. The principal issue in this appeal is whether appellant Medivation Incorporated may reduce its alternative minimum tax liability by utilizing the California Research Credit under Revenue and Taxation Code Section 23609. Hereinafter, we will refer to the alternative minimum tax by the acronym AMT. In 1986, Congress enacted the 1986 Tax Reform Act, which introduced federal AMT provisions. In its analysis of the bill, the Senate Finance Committee noted that it was important, quote, that no taxpayer with substantial economic income avoid significant tax liability by using exclusions, deductions, and credits. Although these provisions may provide incentives for worthy goals, they become counterproductive when taxpayers are allowed to use them to avoid virtually all tax liability. The ability of high-income individuals and highly profitable corporations to pay little or no tax undermines respect for the entire tax system, and thus for the incentive provisions themselves. Additionally, even aside from public perceptions, it is inherently unfair for high-income individuals and highly profitable corporations to pay little or no tax due to their ability to utilize various tax preferences, end quote. In 1988, California's AMT took effect to closely mirror its federal counterpart. Since then, all corporations doing business in California have been subject to California AMT provisions. Here, appellant seeks to use its California Research Credit to circumvent the AMT provisions and avoid all income tax liability for taxable year 2015, despite reporting California net income in excess of $18 million. This position is contrary to the legislature's intent as codified in the plain language of the applicable statutes. Also, this position undermines respect for the research credit itself and for California's entire tax system. It is inherently unfair for appellant, a highly profitable corporation, to pay no income tax on $18 million when other Californians and corporations doing business in California pay their fair share. In support of its position, appellant relies on an obvious misreading of subdivision D1 of section 23036, reinforced by an incorrect and unworkable presidential opinion from the Board of Equalization, appeal of NOSCO Holdings Incorporated. Hereinafter, we will refer to the Board of Equalization by the acronym BOE. In NOSCO, the BOE misinterpreted the plain language of section 23036 to find statutory ambiguity where none exists. In doing so, the BOE created an erroneous rule that is incompatible with the plain language of section 23036 and incompatible with Part 11 of Division 2 of the Revenue and Taxation Code, Corporation Tax Law. NOSCO was wrongly decided in 2010, and any decision by the OTA predicated on its flawed reasoning would be wrongly decided today. Notably, appellant does not rely on section 23609, the statute that allows for the research credit to which appellant claims entitlement. Appellant filed 5 separate briefs in this appeal, and in none of those briefs does appellant even cite to section 23609, not even in a footnote. Perhaps the reason for this glaring omission is the fact that the plain language of section 23609 provides that the research credit is only allowed against, quote, tax as defined by section 23036, end quote. And the definition of tax under 23036 does not include AMT. Appellant also relies on 15 exhibits. Exhibit 1 is the relevant notice of action. Exhibits 2 through 15 represent a combination of carefully selected excerpts from the legislative history of Section 23036 and extraneous documents that were never considered by the full legislature and therefore should be given no weight by the OTA under the applicable case law. Throughout this appeal, respondent has maintained that the OTA's review of legislative history of Section 23036 is inappropriate because the statutory language is unambiguous. However, in the event that the OTA determines that the statutory language is ambiguous, it needs the full legislative record so that it is not misled by appellant's lack of candor in its omitting the full record. Therefore, respondent submitted Exhibit D, which includes 137 pages of the legislative history of Section 23036 from 1989 to present. Exhibit D includes every portion of the legislative history record that relates to the operation of Subdivision D1, including portions that appellant previously submitted and the portions that it selectively excluded from its submissions. This afternoon, my co-counsel and I will divide our presentation into 5 parts. First, I will discuss sections 23036 and 23609, including the mechanics of the statutes and the purpose they serve in the statutory scheme. Second, I will discuss ambiguity, including the legal requirements for a finding of ambiguity and the lack of ambiguity within Subdivision D of Section 23036. Third, I will discuss the flawed reasoning contained in the NOSCO opinion and why it is legally incorrect. Fourth, I will discuss the OTA's authority for removing the presidential status of NOSCO and the imperative for doing so. And fifth, my co-counsel, Mr. Llewellyn, will discuss the correct legal analysis for determining the meaning of tax for purposes of Subdivision D1 only if the OTA first determines that the term tax as used in Subdivision D1 is ambiguous, which it should not. In our presentation, respondent will establish that sections 23036 and 23609 are unambiguous and they do not permit appellant to reduce its AMT liability by utilizing the California Research Credit. We will also explain the rationale and imperative for overturning NOSCO and the OTA's authority for doing so. And lastly, we will establish that even if OTA determines section 23036, subdivision D1, to be ambiguous, the Franchise Tax Board's interpretation is the proper interpretation that is consistent with the legislative intent and consistent with the purposes of the AMT, that all taxpayers pay their fair share. With that, I will turn to 23036 and 23609. As held by the OTA in the appeal of Pino, tax credits are a matter of legislative grace, and taxpayers bear the burden of proving that they are entitled to the tax credits they claim. Statutes granting tax credits are to be construed strictly against the taxpayer, with any doubts resolved in FTB's favor. Section 23036 is contained within Article 2 of Chapter 1 of Part 11 of Division 2 of the Revenue and Taxation Code, which enumerates definitions applicable to Part 11 of Division 2. The first statute within Article 2 of Chapter 1 is Section 23030. It provides, quote, except where the context otherwise requires, the definitions given in this chapter govern the construction of this part, end quote. In other words, the definitions in Chapter 1, inclusive of those definitions provided in Section 23036, govern the construction of Part 11. This statutory construction is consistent with California's longstanding legislative drafting methodology. According to the Legislative Council of California, in its 1975 publication entitled Legislative Drafting Manual, when a word is used in a sense other than its dictionary meaning, the use of a definition at the beginning of the law to which it applies is utilized to avoid repetition of a phrase. The current manual used by the legislature is entitled Handbook on Legislative Drafting in California by Chris McKelly, and it contains similar guidance. Additionally, the current manual provides that a defined term should be enclosed by quotation marks to indicate it is a defined term in the code. In other words, it has a meaning other than its dictionary meaning. This legislative practice of enclosing specifically defined terms within quotation marks is consistent with standard legal style guidelines, as outlined in the Elements of Style by Brian Garner. Consistent with these authorities, every term defined in Article 2 of Chapter 1 of Part 11 is enclosed by quotation marks to designate them as defined terms with specific meanings for purposes of Part 11 other than their dictionary meanings. As relevant to this appeal, subdivision A1 of Section 23036 defines tax for purposes of Part 11. In subdivision A1, the term tax is enclosed by quotation marks, indicating that its subsequent use in the statute and throughout Part 11 is understood to carry the meanings assigned by subdivision A1. In Part 11, the term tax includes 4 enumerated taxes: the corporation franchise tax, the corporation income tax, the tax on unrelated business taxable income of an exempt organization, and the corporation franchise and income taxes imposed on S corporations. Thus, whenever the term tax is used for purposes of Part 11, it means one or more of these enumerated taxes. Subdivision A2 provides for specific modifications to the definition of tax for purposes of Part 11 in the case of certain installment sales. Specifically, subdivisions E1 and F2 of Section 24667 provide for the definition of tax under subdivision A1 with specific modifications to apply to certain installment sales. Subdivision B clarifies that for purposes of administering specifically identified provisions contained within Part 10.2 of Division 2 of the Revenue and Taxation Code, entitled Administration of Franchise and Income Tax Laws, and only for purposes of administering those specifically identified provisions within 10.2, the term tax also includes the annual tax on limited partnerships, the annual tax on limited liability companies, the annual tax on limited liability partnerships, the AMT, the tax on built-in gains of S corporations, and the tax on excessive passive investment of S corporations. If the term tax, as defined in subdivision A1, included any of the taxes enumerated in subdivision B, including the AMT, there would be no need to include the word also in subdivision B. Thus, subdivisions A and B serve as definitional subdivisions. Subdivision A defines the term tax for purposes of all statutory provisions within Part 11, and subdivision B defines the term tax for purposes of certain specified statutory provisions within Part 10.2. Subdivisions D through G of Section 23036 pertain to the treatment of credits in Part 11. As relevant to this appeal, I will discuss subdivisions D and E. Subdivision D1 provides that a credit may not reduce the tax below the tentative minimum tax, except for the 23 enumerated credits listed in subdivision D1. Subdivision D1D includes the research credit as one of these 23 enumerated credits. Hereinafter, we will refer to the tentative minimum tax by the acronym TMT. Notably, in subdivision D1, the term tax is enclosed, again by quotation marks, to indicate the specific meaning of tax under subdivision A1, rather than the general dictionary meaning of tax, which could include a multitude of meanings. Subdivision E provides that any credit which is partially or totally denied under subdivision D is allowed to be carried forward to reduce the tax in succeeding years if the provisions relating to that credit include a provision to carry forward the unused portion of that credit. Together, subdivisions D and E operate to distinguish between those credits that create additional advantages for a corporate taxpayer and those credits that do not. Under subdivision D, if a corporate taxpayer has credits that it can utilize to reduce its regular tax below TMT, it must do so. It pays its regular tax liability plus the amount by which its TMT exceeds its regular tax liability. This difference is the taxpayer's AMT liability. If the taxpayer has an AMT liability, it will also generate the minimum tax credit under Section 23453, which it can carry forward to succeeding taxable years and utilize to reduce its regular tax in one or more of those succeeding years. Therefore, Subdivision D provides corporate taxpayers with two distinct tax advantages. First, if the corporate taxpayer can utilize its tax credits enumerated in Subdivision D to reduce its regular tax below TMT, it is more likely to be able to fully monetize its credits before they expire. Second, by reducing its regular tax below TMT, the corporate taxpayer will generate an AMT liability and therefore will also generate a minimum tax credit that will carry forward to future taxable years. Subdivision E provides that those credits that do not generate a minimum tax credit can be carried forward to reduce regular tax in succeeding years, if the provisions relating to those credits include carry-forward provisions. However, because the taxpayer cannot utilize those credits to reduce its AMT below its to reduce its regular tax below its TMT, that taxpayer will be less likely to be able to fully monetize its credits, and it will be less likely to generate a minimum tax credit to carry forward to future taxable years. Section 23609 provides, quote, for each taxable year beginning on or after January 1st, 1987, there shall be allowed a credit against the tax as defined by Section 23036, an amount determined in accordance with Section 41 of the Internal Revenue Code relating to credit for increasing research activities, end quote. Section 23609 is within Chapter 3.5 of Part 11. Therefore, pursuant to Section 23030, the definitions contained in Article 2 of Chapter 1 of Part 11 apply to Section 23609. This includes the definition of tax under Section 23036, Subdivision A1. For good measure, the legislature specifically identifies the taxes which the research credit is allowed to reduce within the statutory text of 23609 itself. It identifies, quote, tax as defined by Section 23036, end quote. Tax is enclosed with quotation marks, indicating that it refers to the term defined in the code and specifically identifies the statutory definition within Subdivision A1 of Section 23036, as Subdivision A1 contains the only definition of tax for purposes of Part 11. Thus, the plain language of Section 23609 provides that the research credit can only be utilized to reduce a corporate taxpayer's corporation franchise tax, corporation income tax, the tax on unrelated business taxable income of an exempt organization, and the corporation franchise and income taxes imposed on S corporations. Section 23609 is a statute granting a tax credit, therefore it must be construed strictly against the taxpayer, with any doubts resolved in FTB's favor. As appellant hasn't even cited Section 23609 or explained how Section 23609 permits it to utilize its research credit to reduce its AMT, despite its plain language indicating that it cannot, appellant has not met its burden. Therefore, the OTA should hold that pursuant to the plain language of Section 23036, Subdivision D1D, and the plain language of Section 23609, appellant may not utilize its research credit to reduce its AMT. Next, I will discuss the legal requirements for a finding of statutory ambiguity and the lack of ambiguity within Subdivision D1 of Section 23036. In Matei versus Corporate Management Solutions Incorporated, the California Court of Appeal notes the following well-settled principle of law. An ambiguity exists in a statute where a party can identify an alternative, semantically reasonable meaning of a statute. An ambiguity can be patent, arising from the face of the statute, or latent, based on extrinsic evidence. However, a court or tribunal will not strain to create an ambiguity where none exists. Furthermore, in another case, Monette versus San Francisco Board of Supervisors, the Court of Appeal notes an additional well-settled principle of law. That is, extrinsic evidence should not be used to discover ambiguity when statutory language appears to be plain on its face. In other words, the circular use of extrinsic evidence cannot be used to both create and resolve ambiguity in a statute. The plain language of Section 23036 is unambiguous. For purposes of Part 11, the term tax includes those 4 enumerated taxes. Thus, whenever the term tax is used for purposes of Part 11, it means one or more of these 4 enumerated taxes. Throughout the proceedings in this appeal, appellant has failed to identify any alternative semantically reasonable meaning of subdivision D1. When pressed to do so, essentially it has 2 responses. First and foremost, it argues there is ambiguity because the BOE says so. And second, it argues that there is ambiguity because certain carefully selected excerpts of the legislative history of Section 23036 create ambiguity. Therefore, the OTA should use these selected excerpts to resolve the ambiguity which these same excerpts created. In other words, the circular use of extrinsic evidence to both create and resolve ambiguity, the use of which was rejected by the Court of Appeal in Monette. So what is appellant's alternative semantically reasonable meaning of tax for purposes of subdivision D? Appellant never answers that question. Here again today, appellant essentially states, because the BOE says so. As another state agency, by definition, they are reasonable. Whether the BOE is reasonable as an agency or unreasonable is not the point. The question is whether there is an alternative meaning of the statute that is semantically reasonable, not whether the alternative meaning is made by a reasonable agency. What appellant refuses to admit is that their unspoken alternative meaning is not only semantically unreasonable, it is nonsensical. As outlined by the Court of Appeal in People versus Johnson, when construing statutes, courts avoid interpretations and constructions that defy common sense or that might lead to mischief or absurdity, including literal meanings that would lead to a result not intended by the legislature. Yet, this is what appellant asked the OTA to do. Using appellant's definition of tax, that is, to include AMT, subdivision D1 would read, a credit may not reduce the AMT below TMT, except for the 23 enumerated credits listed. However, the TMT is not a tax. Rather, it is a computation utilized to calculate a taxpayer's AMT. The AMT is the difference between a taxpayer's regular tax and its TMT if regular tax is less than the AMT. In our briefing, respondent asked the question, how can a credit reduce a computation utilized to calculate a taxpayer's AMT below a taxpayer's AMT? It is an impossible calculation because the TMT is a computation utilized to calculate the AMT. Appellant fails to ever reconcile subdivision A1 with its unspoken definition of tax in subdivision D1. In other words, appellant also never answers the following question. If subdivision A1 defines the term tax for purposes of Part 11 and subdivision D1 is within Part 11, why does the definition of tax in subdivision A1 not apply to subdivision D? In addition to rendering subdivision D nonsensical, interpreting tax for purposes of subdivision D to mean anything other than the 4 taxes identified in subdivision A1 renders subdivision A1 superfluous. Why enact a definitional statute that is inapplicable to the word that it defines? If the use of tax in subdivision D1 is ambiguous, is every other use of the term tax within Part 11 also ambiguous? And if not, why not? Appellant does not explain this. Again, here today, appellant refuses to explain how their unspoken interpretation is semantically reasonable. Appellant's interpretation is exactly the type of interpretation that is to be avoided according to the California Supreme Court. In Dynamed Incorporated versus Fair Employment and Housing Commission, the court held that courts must avoid the construction of terms that would, quote, generate surplusage elsewhere in a statute, end quote. This opinion reinforces the core principle of the anti-surplusage canon. The legislature is presumed to use each term in a statute meaningfully and purposefully, not redundantly. Here, appellants ask the OTA to interpret subdivision D1 in such a way as to render the definitions provided in subdivision A1 as mere surplusage. This leads to the BOE's opinion in NOSCO. Prior to the BOE's formal opinion in NOSCO, respondent maintained that the only credits available to reduce a taxpayer's AMT liability were those credits whose statutes provided for such a reduction of AMT. Despite the plain language of Section 23036, in NOSCO, the BOE erroneously determined that patent ambiguity exists in the statute. The BOE states the following, quote, "The statute does not clearly express the meaning of the term tax for purposes of subdivision D1. While respondent would have us apply the definition as set forth in subdivision A, that section includes some types of tax and excludes others, but does not specify where AMT falls in this definition." End quote. This statement ignores the plain language of Section 23036 and the purpose it serves in the statutory scheme. As I explained, Section 23036 is within Article 2 of Chapter 2 of Part 11, which enumerates the definitions for Part 11. In other words, Subdivision A defines tax for purposes of administering Part 11. Contrary to the BOE's conclusion, Section 23036 clearly expresses the meaning of the term tax for purposes of Part 11 and for Subdivision D1, which is within Part 11, and AMT is outside of that definition. Also in NOSCO, the BOE erroneously determined that latent ambiguity exists in the statute. As articulated by the Court of Appeal in Coburn versus Sievert, latent ambiguity exists when the literal application of the statute would frustrate the purpose of the statute or would produce absurd consequences. The BOE compared two taxpayers, one taxpayer whose regular tax is 0 with an AMT liability equal to the full value of its TMT, and a second taxpayer with a regular tax equal to or greater than its TMT. If applied as the FTB argued, the first taxpayer would have an AMT imposed that is equal to the full value of its TMT, whereas the second taxpayer would be able to reduce its regular tax to 0 if it had available easy hiring credits. The BOE characterized these two different outcomes as, quote, essentially penalizing a taxpayer with available easy hiring credits and a lower regular tax, end quote. However, the BOE failed to take the next step in the analysis and recognize that the taxpayer who is not able to reduce its regular tax below TMT with credits in the first taxable year would carry forward those credits to future taxable years, whereas the first taxpayer would have exhausted those credits in the first taxable year. Also, both taxpayers would pay amounts equal to their TMT, one with regular tax alone and one with AMT. Both taxpayers would pay the same amount of tax. Far from absurd, this result is precisely what the legislature intended and is consistent with the ordinary application of the AMT scheme. Further, the BOE failed to identify any alternative semantically reasonable meaning of subdivision D1. Its apparent unspoken alternative meaning is the same as appellants, that is, quote, a credit may not reduce AMT below TMT, end quote. As I previously explained, this alternative meaning is not only semantically unreasonable, it is nonsensical. Furthermore, once the BOE determined incorrectly that the tax in subdivision D was ambiguous, it failed to apply the correct legal analysis as required by California's Supreme Court precedent in People versus Woodhead and Yamaha Corporation of America versus State Board of Equalization. My co-counsel will discuss the analysis that the BOE should have employed, and that analysis favors respondents' interpretation of subdivision D1. Appellant claims that BOE already reviewed its opinion and determined that it was not contrary to law. However, appellant fails to indicate that the opinion on the substantive issues in the case was a single-page summary document that did not explain the legal basis for the BOE's opinion, that is, Respondent's Exhibit C. The opinion on petition for rehearing is the first and only opinion in which the BOE explained the legal basis for its decision. At the time, like today, there is no procedural basis for a petition for rehearing on an opinion on petition for rehearing. Therefore, this is the first time the FTB has had the opportunity to even address the NOSCO opinion. The NOSCO opinion was incorrect in 2010, and it is incorrect today. Therefore, the OTA should overturn NOSCO and remove its precedential status. Pursuant to California Code of Regulations, Title 18, Section 30503, OTA may withdraw in whole or in part the precedential status of an opinion, including a State Board of Equalization opinion on a subject over which OTA has jurisdiction previously designated as presidential. FTB does not make this request to overturn a presidential BOE opinion lightly. We understand the significance of overturning NOSCO. However, a precedent should be set aside if it has proven to be unworkable in practice and poorly reasoned. Overturning NOSCO is entirely consistent with California Supreme Court precedent. In the People versus Latimer, the court stated, quote, "The reasons for adhering to stare decisis are outweighed by the reasons for reconsidering and correcting an erroneous rule," end quote. The BOE's opinion in NOSCO creates such an erroneous rule that is incompatible with the plain language of the statute and inconsistent with the purpose of the AMT, that all taxpayers pay their fair share. Having explained the proper operation of Section 23036 and 23609, the lack of ambiguity within subdivision D1, the errors in the BOE's opinion in NOSCO, and why the OTA should remove its precedential status, I will turn to my co-counsel, Mr. Llewellyn, who will discuss the parties' exhibits and the proper legal analysis that the OTA should apply only if it first determines that subdivision D is ambiguous, which it should not.
Only if OTA finds that section 23036 is ambiguous, which is demonstrated it is not, should OTA engage in further statutory construction analysis. To analyze ambiguous statutory language, courts may consider extrinsic evidence to determine the meaning of a statute. The extrinsic evidence that a court may consider can be grouped into three broad categories, which I will discuss as follows. The first is the administrative agency's interpretation. The second is the objectives of legislation, including legislative history and public policy. And the third is the statutory scheme of which the statute is a part. I'll begin with FTB's interpretation of Section 23036. The degree of deference given to an agency's interpretation is governed by the California Supreme Court case Yamaha Corp. of America versus State Board of Equalization. In that case, the court held that the appropriate degree of judicial scrutiny and administrative agency's rules and regulations in any particular case is not a precise formulation, but lies somewhere along a continuum, with non-reviewability at one end and the exercise of independent judgment at the other. A court assessing the value of an interpretation must consider factors material to the substantive legal issue before it, the particular agency offering the interpretation, and the comparative weight the factors ought to command. In its precedential 2023 opinion, Appeal of Southern Minnesota Beet Sugar, OTA summarized these factors as follows. 1, the technical expertise of the agency and the complexity of the matter. 2, whether the agency's interpretation has been consistent. And 3, whether the interpretation has been formally adopted in regulations. In this case, FTB has extensive expertise in administering its tax programs, including, as relevant here, complex areas such as the AMT. This factor should weigh in favor of deference to FTB's interpretation of Section 23036. Although FTB's interpretation has not been formally adopted in regulations, its interpretation is supported not only by the plain language of the statute, but also by FTB's longstanding and consistent interpretation of the statute. This interpretation, that is, that Section 23036, Subdivision D refers exclusively to the tax as defined under Subdivision A, is evident through FTB's published instructions and tax forms that date back to 1988. FTB's Exhibit E consists of copies of instructions for FTB Form 100 insofar as it relates to AMT, as well as the relevant portion of Form 100 where taxpayers compute and report their AMT liability. FTB has included tax forms and instructions for the taxable years 1988 through 1994 inclusive. These instructions and corresponding forms clearly set forth FTB's interpretation of the intent of Section 23036 by specifying which credits may reduce regular tax down to the TMT, which credits may reduce regular tax below TMT, and which credits may reduce AMT. For example, the instructions and tax forms for these years correctly show that the only tax credits that may reduce AMT are the credits for solar energy and commercial solar energy systems, as provided for under former sections 23601 and 23601.4 respectively. The plain language of former section 23601.4 specifically allowed the commercial solar energy system credit to be taken against AMT. FTB's instructions and forms therefore correctly state that the former commercial solar energy credit, system credit, may reduce AMT. Former section 23601 specifically allowed the credit for solar energy systems against the taxes imposed by this part, and that's in quotations, except for the minimum franchise tax and tax on preference income. The phrase "this part," in quotations, refers to Part 11 of the Revenue and Taxation Code, known as the Corporation Tax Law, under which the corporate AMT is found. Because AMT is a tax imposed by Part 11, and former Section 23601 did not explicitly prohibit the solar energy system credit from reducing AMT, FTB's instructions and forms correctly state that the solar energy system credit may reduce AMT. FTB has also included in its Exhibit E FTB instructions and forms for 2010 and 2015 to demonstrate how these forms were updated following the BOE's decision and NASCO. These forms reflect the BOE's opinion that the Easy Hiring Credit and the MIC may reduce AMT, notwithstanding the fact that neither of these credits authorizing statutes specifically allow for these credits to be claimed against AMT. Apart from FTB's demonstrated long-standing and consistent interpretation of Section 23036 is the legislature's and public's acquiescence to and adoption thereof. In his concurring Yamaha opinion, Justice Mosk states that an agency's interpretation of a statute is owed judicial deference when it is relied upon by the business community and the general public to order their affairs, and after sufficient passage of time, is presumptively accepted by the legislature. Such is the case here. As I previously discussed, the public and business community have relied on FTB's interpretation as communicated on its tax forms and instruction manuals since the late 80s. In other words, taxpayers have relied on FTB's interpretation of Section 23036 in computing their regular tax and AMT liabilities. As discussed earlier, because the plain language of Section 23036 is unambiguous, OTA should not resort to legislative history to determine the intent of the legislature. However, the legislative history of Section 23036 shows that the legislature's interpretation of the application of the research credit is consistent with FTB's interpretation thereof. This leads to the second category of extrinsic evidence that courts may use to resolve ambiguity in a statute, the objectives of legislation, including legislative history. In examining the legislative history of Section 23036, however, we are faced with both practical and legal limitations. The first is that, according to the California Secretary of State, the California legislature does not transcribe hearings and other daily activities like the United States Congress does for its own legislative activities. As a result, there are many legislative hearings for which no verbatim transcript exists. Second, even where statutory language is ambiguous and a review of legislative history is appropriate, legislative history must shed light on the collegial view of the legislature as a whole. For example, in the California Supreme Court case, Quintano versus Mercury Casualty, The court held that the statements of an individual legislator, even including the author of the bill, are generally not considered in construing a statute, as the court's task is to ascertain the intent of the legislature as a whole in adopting a piece of legislation. In addition, the Court of Appeal in Halbert's Lumber versus Lucky Stores Incorporated stated that while the language of a statute has been lobbied for and against, studied, proposed, drafted, restudied, redrafted, voted on in committee, amended, re-amended, analyzed, reanalyzed, and then voted on by two houses of the legislature, among other activities, such cannot be said about any other document that may make up a statute's legislative history. Appellant has submitted several documents that purport to represent the legislative history of Section 23036 as it relates to the research credit. Among these, as we've discussed, include Exhibit 2, which consists of a proposal of the contents of AB 802 from 1988. This added the research credit to 23036 Subdivision D. Exhibit 3, consisting of a letter from AB 802's governor, or AB 802's sponsor to the governor. Exhibit 4, a bill analysis from an unrelated credit. Exhibit 5, consisting of documents from the Governor's Office of Planning and Research related to legislation for credits, also unrelated to the research credit. Exhibit 6, which is a 1992 document containing FTB's preliminary findings on AMT statutory provisions. And Exhibit 7, a 1992 third-party manual on California income tax laws. Apart from the bill analysis for an unrelated credit, there is no evidence showing that these documents were ever presented to the legislature for consideration or discussion, such that these documents cannot be said to represent the collegial view of the legislature as a whole. Therefore, these documents should not be considered part of the legislative history of Section 23036 for purposes of ascertaining the intent of the legislature regarding the research credit. Furthermore, while appellant has selected a handful of instances where it is suggested that the research credit may reduce AMT, FTB's Exhibit D sets forth numerous other examples of legislative history stating the correct application of the research credit to reduce regular tax below TMT. Exhibit D contains at least 4 separate bill analyses from various legislative committees that state the correct intent of AB 802, as relevant here was to add the research credit to the list of those which are allowed to reduce regular tax below TMT. These examples can be found on pages 5, 13, 20, and 28 of Exhibit D, some of which were read aloud by appellant's counsel today. So rather than ignoring the legislative history, as also stated by appellant's counsel earlier, FTB has reviewed and submitted the legislative history across nearly 2 decades following AB 802, and has found that the legislature has used nearly identical language in bill analyses for other credits under Section 23036, each stating that these credits are to be added to the list of credits that may reduce regular tax below TMT. These include AB 57 in 1993 for the Enterprise Zone Hiring and Sales Tax Credit. This is Respondent's Exhibit D, pages 41 and 42. AB 1173 in 2013 for the Motion Picture Tax Credit, which is found on pages 45, 93, and 96 of Exhibit D. In AB 1115 from 2001, this is found on pages 77 through 92, the legislature also demonstrates its understanding for the difference between credits that may reduce AMT versus credits that may reduce regular tax below TMT. This relates to the order in which these respective credits may be applied, requiring that AMT credits be applied before any credit that can reduce regular tax below TMT. Nevertheless, a final and perhaps overlooked limitation of examining legislative history is the inevitability of human error and inconsistency. For example, an analysis of AB 1313 from 1994, this is on page 67 of Exhibit D, as it relates to the Los Angeles Revitalization Zone credit, states that the credit may reduce, quote, the tentative alternative minimum tax. And this was also read aloud by appellant's counsel today. Once again, that is tentative alternative minimum tax. there is no such thing as a tentative alternative minimum tax. Rather, the analysis clearly conflates TMT with AMT. Two separate bill analyses from AB 1839 from 2014, as it relates to the motion picture tax credit, also erroneously use TMT and AMT interchangeably. An analysis from the Assembly Committee on Revenue and Taxation, this is page 116 of Exhibit D, initially states that the credit will not be expressly added to the list of credits that may reduce regular tax below TMT. These are found under subdivision D1. In a subsequent Assembly Appropriations Committee analysis for the same bill, the authors propose an amendment to, quote, conform to existing law by allowing the credit to be used to reduce a recipient's tax below the AMT and therefore fully monetize the credit, end quote. Simply based on the language used, this is clearly an example of one committee incorrectly substituting AMT for TMT. Even if we were to accept the Appropriation Committee's use of the term AMT, their reasoning for the amendment is a non sequitur, because, as explained earlier, the existing motion picture tax credits were only able to reduce regular tax below TMT, not AMT. Yet another error is apparent in analysis from AB 2574 from 2014 as it relates to the GoBiz California Competes credit. This is found on pages 126 through 128 from Exhibit D and was also read aloud by Appellant's counsel today. This states that the bill would allow taxpayers to use the credit to, quote, reduce TMT. As my colleague has already explained, TMT is not a tax. Rather, it is used in the computation to calculate AMT. Therefore, while there are credits that may reduce regular tax below TMT, thus generating an AMT liability, it is inaccurate to state that a credit may reduce TMT. Therefore, the purported legislative history on which appellant relies, including a few instances from AB 802 and other miscellaneous statutes where it may state that the research credit or other credits as discussed, which included the college access credit and the aircraft credits, these may very well be other examples of the legislature erroneously conflating reducing AMT with reducing regular tax below TMT. Lastly, the third category of extrinsic evidence courts may use in resolving legislative ambiguity is looking to the statutory scheme of which the statute is a part. Courts must read statutes as a whole so that all parts are harmonized and given effect. As discussed earlier, for purposes of Part 11, Section 23036 defines tax as the corporation franchise tax, the corporation income tax, the tax on unrelated business taxable income of exempt organizations, and the tax imposed on California S corporations. Subdivision B clarifies that only for specifically identified provisions contained in Part 10.2 of the Revenue and Taxation Code, the term tax also includes certain provisions contained in Part 11, such as AMT. As such, the tax referenced in Subdivision D1, which is found not only under Part 11, but also within the same statute in which the term tax is defined for purposes of Part 11, does not include AMT. In summary, the definition of tax for purposes of Subdivision D1 must be examined in the context of the statute, and as explained, the only logical answer is that definition set forth in Subdivision A. If you'll indulge me, by way of analogy, a classic anecdote from 20th century linguist and fire prevention engineer Benjamin Lee Whorf involves his inspection of a chemical plant with 2 storage rooms for gasoline barrels, one for the full barrels and one for the empty ones. Whorf observed that the chemical plant's employees never smoked in the room with the full barrels, but that several employees smoked in the rooms marked as having empty barrels. As one can imagine, in a chemical plant, the supposedly empty barrels were significantly more dangerous when exposed to open flame due to the flammable vapors still contained therein. Whorf concluded that the employees saw the word empty and assumed the most expansive and ultimate definition of that word, rather than taking the word into context of being an empty gasoline barrel that still likely contained flammable residue. Here, appellant has taken the word tax out of its context of the statute, in which it is clearly defined, and appellant has incorrectly expanded its meaning beyond the statute's plain language, which could render the entire statute inoperable. In other words, appellants has struck a match next to a gasoline barrel marked empty while failing to look around and note it is still located inside a chemical plant. Based on the foregoing, FTB's long-standing and consistent interpretation of Section 23036, its legislative history, and the statutory scheme of which the statute is a part, all support FTB's position that the research credit may not be used to reduce AMT.
And to summarize our presentation, respondent has established that sections 23036 and 23609 are unambiguous and they do not permit appellant to reduce its AMT liability by utilizing the California Research Credit. Respondent has also explained the rationale and imperative for overturning NOSCO and OTA's authority for doing so. Lastly, respondent has established that even if the OTA determines section 23036 subdivision D1 to be ambiguous, the Franchise Tax Board's interpretation is the proper interpretation that is consistent with legislative intent and consistent with the purpose of the AMT, that all taxpayers pay their fair share. Accordingly, respondent requests that the OTA correct the BOE's legal error and remove the precedential status of NOSCO. Additionally, respondent requests that the OTA hold that based on the plain language of section 23036, subdivision D1D, and the plain language of section 23609, appellant may not utilize its research credit to reduce its AMT. On this basis, respondent requests that the OTA sustain the Franchise Tax Board's notice of action, affirming its notice of proposed assessment. Thank you, and at this time, we are happy to answer any questions that the panel may have. Oops.
Thank you. We'll turn to the panel for any questions, starting with Judge Gast.
I'm not sure if, Mr. Miller, you had a chance to look at 23609 when it was first enacted and how it disallowed the use of the credit against the AMT. It was explicit, and then that was removed by SB 1801. I don't know if you had any thoughts on that or comments.
There we go. I don't have any comments other than to say we're dealing with the current version, which explicitly references the definition set out in subdivision A1 of 23036. And that's the version we're dealing with regard to appellant's taxable year of 2015. I don't want to pontificate about what the legislature intended without documents before us.
Okay, thank you. No further questions.
Thank you, and Judge Lambert.
I don't have any questions. Thanks.
And no questions at this time for myself, so we'll turn back to appellants. You have up to 30 minutes for rebuttal.
Thank you. All right, so I apologize in advance if I'm going to jump around a little bit, but it's more according to my notes as respondent was speaking. So first of all, I'd like to say that while it is agreed that the reason for the AMT is to make sure that corporations pay some tax. However, as I've stated earlier, there are some tax credits that the California legislature have found to be of overriding importance, that they're willing to let the taxpayers reduce their AMT with those tax credits. When respondent is talking about how this is unfair, if taxpayers are allowed to use their tax credits, their research tax credits to reduce the AMT because they're highly profitable, and that if allowed to do so, then they will reduce their tax to zero. However, by respondent's own admission, if the regular tax is above the TMT, that taxpayer can reduce their tax to zero. So how does that square with a policy that the respondent just said that every taxpayer should pay something? It doesn't. And in terms of, the next thing is that FTB respondent says that appellant has not referenced 23609. That is not at issue here. The credits claimed, the amounts claimed, not at issue. FTB does not dispute what we have claimed. They're disputing whether we can claim it to reduce the AMT. 23609 does not matter to this issue. The FTB tried to argue that again in NASCO as well, talking about how the easy hiring credit and the MIC did not include a section saying that you could reduce it, use it to reduce the AMT. And the BOE also disagreed with them on that point. But looking at 23036D, it says here, notwithstanding any other provisions of this part. Notwithstanding any other provisions of this part. We're looking at 23036. 23609, since the R&D credit amount is not at issue, is irrelevant. I think next, the FTB talks about how appellant lacked candor by not including all ledge history. I think appellant is being disingenuous here. For the entire 2.5 years we've been doing this appeal, all the briefings, even prior to that during protest, the years during audit, nothing has been said about ledge history. Legislative history has not been mentioned, except until 14 days ago with Exhibit D, 137 pages. 137 pages doesn't, FTB claims includes all ledge history relating to all the credits in subdivision D1. That is clearly not true, clearly not true. So who lacks candor here? As I stated, there are other credits that were added after the GoBiz. And the last bill in Exhibit D relates to the GoBiz credit. As for whether NASCO should be overturned, respondent referenced several cases. We would like to point to this panel also other cases. In Lucent Technologies, we have here that while courts may have some latitude to disregard decisions of the sister courts, they only exercise that latitude when there is good reason to do so. Courts are especially hesitant to overturn prior decisions where, as here, the issue is a statutory one that our legislature has the power to alter. This is what we're talking about here. We are talking about a statute. FTB says their interpretation is the only correct one, no other interpretation. While they agree that the SBE could be a reasonable agency, they have stated throughout their briefs that the SBE's or the BOE's reasoning is flawed, nonsensical, and contrary to law. The reasoning. We are not talking about whether the BOE itself is a reasonable agency. We are talking about the reasoning because that's what respondent has put before this panel, is that question, whether the NASCO decision is sound, whether it is supported by law, whether it is a reasonable interpretation, whether it was correct. Not whether the FTB liked the decision, agree with the decision. That is not the standard here. The burden is on the party that is trying to overturn a decision. And here, in this case, that is respondent. That is the FTB. They have the burden. Courts do not overturn prior decisions, even of sister courts, easily. They don't do it frivolously. They don't do it, just because one of the parties didn't like the prior decision. For the stability of the legal system, predictability, reliability. A prior case, even of a sister court, cannot be overturned without really good reason, without substantial justification. And FDB has not provided that, other than that it just disagrees with the NASCO decision. And in terms of ambiguity, I would like to read for this panel, the Herc-Celanese decision, which, as you know, is a California Supreme Court decision. It says here, if it is susceptible to, basically the statutory language, if it is susceptible to more than one reasonable interpretation, then we look to the extrinsic aids, including the ostensible objects to be achieved, the evils to be remedied, the legislative history, public policy, contemporaneous administrative construction, and the statutory scheme of which the statute is a part of. In Lundgren, as I noted earlier, it also says that court looks to the legislative history for clues of legislative intent. And the intent prevails over the letter. And the letter will, if possible, be read as to conform to the spirit of the act. And lastly, Coburn, which is also mentioned by the FTB. In Coburn, it says, it says, because legislative intent prevails over the words actually used. However, where a party argues a latent ambiguity exists, a court may not simply adopt a literal construction and end its inquiry. A latent ambiguity exists where some extrinsic evidence creates a necessity for interpretation or a choice among two or more possible meanings. Such a necessity is present where a literal construction would frustrate rather than promote the purpose of the statute. So all this tells us that we need to look at the leg history. It's ambiguous, as I noted. The FTB has not addressed the fact that FTB likes to say, FTB has argued that 23036A1 defines tax to include only these. As I explained earlier, includes, the word includes means it's not exhaustive. It's not limiting. It's not the same as means or defined as or includes only. D1 has the word tax, but is not defined. It has the word, or has the term tentative minimum tax. That is defined. And then again, I go into 23036I, there it talks about regular tax, also defined. Therefore, in the same statute, you have some parts that have definitions, some parts that do not have definitions, and yet the FTB wants you to find that there is only one interpretation, that somehow the quoted term tax under D1 must mean regular tax. It is simply not supported by the statute, and therefore we must look at the legislative history. FTB then argues that appellant carefully selected certain excerpts. Again, this is not true. These excerpts clearly show appellant did not choose these because these are the only ones that support us. Even Respondents Exhibit D, as I noted and read through earlier, are replete with examples where it is absolutely clear that these credits could be taken against AMT. However, the FTB, instead of trying to explain that away, simply says, oh, they must be confused. They didn't mean to use that term. Oh, they must have confused this term with that term. This is sort of a pattern for the FTB in this case. If they disagree with you, you're nonsensical. If they disagree with you, your reasoning is flawed. If they disagree with what's on paper, then, oh, the author misunderstood. They don't know what they mean. Yet, apparently, in all these statements, FDB's message is, only we are correct, nobody else is. How can that be? That is not how tax law is made, that whatever FDB says is the law. That is why we have the OTA, that is why we have the courts, that is why we have debate among the legislators when these things are put forth. While the FTB claims that, for example, that the letter that Mr. Clays wrote to the governor and urging him to sign, that was a letter, just a letter. However, that was a letter explaining to the governor of California why this bill is necessary and why they should sign it. That is not important? That doesn't mean anything? How can that be? It's impossible to believe that all this document means nothing. So when FTV puts forth their own 137 pages of exhibits, what does it mean? They selectively choose the ones that seem to support their position, but those that don't, then people are confused. That cannot be how this case is viewed. That cannot be how tax law is determined. And one last thing is, the FTB claims that, taxpayer is not, I assume this is what FTB is arguing, that taxpayer is not at a disadvantage, because if they cannot use the credits to reduce their AMT in the current year, they can carry it forward. Why is a taxpayer in a similar situation using the same credits that are encouraged by the legislature for purposes of that economic activity be treated any different just because their TMT is higher than their regular tax versus the other way around? Why should they have to wait another year? And what happens if next year their TMT is also above their regular tax? They have to carry it forward another year, and the year after that, and the year after that, what, in perpetuity? That cannot be how these credits were enacted. That cannot be what the legislature meant when they said some credits are of such overriding importance that they are allowing them to be used against AMT. So, in conclusion, we'd just like to repeat that the FTB has not demonstrated that NASCO was wrongly decided, that NASCO should be overturned. NASCO is a 15-year presidential decision. The legislature has added several credits since then to subdivision D1, and they have all said, you can use the credits against AMT. There is ambiguity in 23036. Ledge history should be reviewed, and the history overwhelmingly support taxpayers' position that it can use its research credits to reduce its AMT. And for all those reasons, we urge this panel to find in favor of the taxpayer and hold that appellant can use its research credit to reduce its AMT. Thank you.
Thank you, and we'll turn back to the panel for questions, starting with Judge Gast.
No further questions, thank you.
All right, and Judge Lambert?
No questions, thanks.
I do have a question. We'll go to Franchise Tax Board. I believe you touched on this in your briefing, but the FTB Notice 2011-02, it's specifically worded following NASCO to denote that NASCO only applies to the easy hiring credit and the MIC. Is there a position that you're presenting that NASCO, maybe if it's not overturned, is still distinguishable? Or is the position solely that NASCO is overturned, or if it's not overturned, then the ledge history shows that you still prevail?
I'm sorry, I want to make sure I answer your question or questions. It sounded like you had several. So if you could you ask the first one first, and I'm happy to answer all of them.
Sure, sure.
Thanks.
Is there an argument that NASCO is distinguishable because of the credits it dealt with versus the credits here today?
It's distinguishable from, the NASCO decision did not deal with the research credit, right? So it's distinguishable on that basis, correct. But as we have explained and presented, the NASCO decision is wrong and incorrect. It was wrong as pertaining to the easy hiring credit and the manufacturer's investment credit as well at that time.
Okay, thank you. I believe that answers
Mhm.
both questions there. But I'll turn to
Thanks.
appellants as well. Is NASCO distinguishable because of the credits?
We do not think so. NASCO itself, while it does specifically focus on the easy hiring credit and the MIC, it is not limited to that. It talks about 230361, whether it's ambiguous, and then it does talk about the MIC and the easy hiring credits because those were the only credits at issue. However, it does not exclude other credits. However, I should point out, and I don't have the transcript in front of me, but during the oral arguments for NASCO, the question was posed whether if 230361, if they find that there's ambiguity and that it applied, all the credits under D1 would also be able to be used against AMT. Believe that FTB at NASCO during an oral hearing said yes. But aside from that is the fact that the reasoning in NASCO should hold in this case as well, that there's ambiguity in the statutory language, and therefore you should look at the ledge history. And the ledge history here, as I noted that we presented AB 802, which is specific to the research credit, AB 57, which is to the easy and the hiring credit, which the NASCO, BOE and NASCO reviewed, is that it references the research credit and how, just like the research credit, the easy hiring and the MIC credits should be allowed to reduce the AMT. And therefore, I don't think NASCO is distinguishable in that sense. The credits themselves, respondent is correct, NASCO did not talk about a research credit specifically because that credit was not at issue.
Okay, thank you. Along these lines, for Franchise Tax Board, I know the easy hiring credit and MIC may not be relevant these days, but if NASCO were overturned, what would happen to those credits in FTB's interpretation of whether those credits could be applied against the AMT going forward?
Well, the result would depend on the OTA's ruling and your holding, but as you stated, the easy hiring credit and the manufacturer's investment credit are really no longer relevant for the most part. The manufacturer's investment credit expired in 2004, and the easy hiring credit expired in 2014. And both of those provisions had carryover provisions for only 10 years. So the latest some taxpayer could claim a carryover for an easy hiring credit would be December 2023. So those really aren't coming up at issue. But depending on the OTA's ruling, you would either deny the use of those credits against the AMT or whatever the OTA decides to do. But that is our position. We think it should be overturned in completely, and any use of the carryovers for the easy hiring should be disallowed against the AMT. Does that answer your question, Judge?
It does, thank you.
Okay, thanks.
And this might be for your partner, Mr. Lowen, up there, but going to the discussion of the legislative history and the consistency of the tax agency's position, should we view FTB Notice 2011-02 and FTB's forms, instructions, and actions regarding the credits at issue in NASCO the past dozen years or so, when looking at the tax agency's consistency and determining whether NASCO should be overturned. Does that make sense?
I think I'm understanding the question. If I can rephrase, are you saying should FTB notice 2011-02 and the FTB's allowance of the easy hiring and manufacturer's investment credit against the AMT be used in an analysis of our longstanding position?
Yeah, I guess I should say when looking whether to overturn NASCO, and Exhibit E talks about instructions on the
Yes.
forms.
Right. Well, as you know, the forms changed only after NASCO was decided to allow the easy hiring and manufacturer's investment credit against the AMT. We were bound by the BOE's presidential decision. So of course we followed the BOE's presidential holding that required us to allow those two credits against the AMT. And as I noted in my briefing, this is the first time that we've had an opportunity to even address the NASCO decision, because being such a tax-favorable decision, it's not really litigated by taxpayers in claim for refund litigations. And the only opportunity for us to address it is, this is the first time we've had a chance to actually address it and address its incorrectness. Does that answer your question?
That helps, yes, thank
Thanks.
you. That's the last of my questions, unless the co-panelist has another question. All right.
I'm sorry, Judge Johnson, if I may, could I address your last point as well? Or-
Yes, please do.
Okay. So in terms of the longstanding FTB position in overturning NASCO, I think that was your question, if I understood correctly. I don't think that should be considered, because the FTB, as I noted earlier, in 1992, FTB took a position that is the same as the NASCO position. Even today, the FTB does not address why that decision, that analysis, that study, that report that took over 5 years to put together is somehow wrong. And I know the FTB referenced Yamaha, but you cannot consider an agency decision as being longstanding if it vacillates, and it did. So, I do not believe that FTB's quote-unquote longstanding position on this issue should be the reason to overturn NASCO. Thank you.
Thank you. With that, we are ready to submit the case. Evidence has been admitted into the record, and we have the arguments in your briefs as well as your oral arguments presented today. Thank you for those. We now have a complete record from which to base our decision. Any final questions before we conclude today from appellants?
No.
Thank you. And from respondent?
No, thank you.
Thank you. Wished again to thank both parties for their efforts in this matter. This concludes the hearing for this appeal. The parties should expect our written opinion no later than 100 days from today. With that, we are now off the record. This concludes the Office of Tax Appeals hearings for today. OTA hearings on other matters will begin again tomorrow morning here in Sacramento. Thank you, everyone.